Mr. B.
Hi.
Today's question is from Lola.
Uh-huh.
Her child has special needs. Their lawyer has advised to do an application on Article 3 medical grounds. Do you agree?
Ooh, no, I don't agree with that because Article 3 medical grounds talk about a rapid decline in your health. It has to be something urgent. It has to be something so bad that it will put you through intense suffering.
Life or death?
Oh, well, yes. If I went on to say that if there was a situation where somebody's in the UK and he's got some disease and he is likely to last, I'm saying a very cold kind of selection
That's
of words
how they
here,
see it.
right? That's how they see it. So if they say that this person, if in the UK, with this medical condition, with treatment in the UK, will probably live for another 12 months. But if he were to go back to his country, he will die within 6 months. They will still not give you status on Article 3. That's how high the threshold is. AM Zimbabwe is the case, Papashwali is the case, N used to be the original case that all these medical reasons went into. So when there is a medical issue, either it has to be up to that level of that intense suffering or that rapid decline in the health, or if it is not up to that level, then don't argue Article 3. Then you can argue another point, which is the significant difficulties in settling back in your country, because that is part of the PL rules in the immigration rules. So when you look at that, when you look at a situation, well, this situation where they say that the child has special needs and there would be difficulties for the child to settle back in their country, that would be a much more and a much more arguable point for the family to make. That, okay, husband, wife, other children, and this child, if they were to go back to their country and they do not get the proper treatment or the care for that child with special needs, then they will have significant difficulties in settling back because of the whole scenario. If instead they go under Article 3, then the Home Office letter will straight away list out all these cases that I've talked about, go into all those different hospitals or clinics that you can find in their country and say, you can go here, you can go here, you can go here. It doesn't matter if this is 1,000 miles away from where you live or this is 500 miles away from where you live. But because there are these hospitals available there, you can easily go there. The other thing is that if they do make an Article 3 claim, more often than not, I've seen those claims being refused and certified as clearly unfounded, which means that they will not even get a right of appeal to challenge it. And that is very frustrating because then what you're doing is your lawyer will then advise you to go into a judicial review matter. A judicial review would mean pre-action protocol first, then the judicial review application. And what are you saying? That the Home Office have made a wrong decision on Article 3, which I don't think they have. So if you've made a case for Article 3 and the Home Office refuses it because of the very high threshold, you're unlikely to succeed in a judicial review as well. So the better thing to do would be make a human rights application, argue on the significant difficulties in settling back because of the circumstances surrounding the child, and then if they refuse, you will get a right of appeal. Then when you are in front of an immigration judge, you gather all your evidence, your arguments are there, and then you go and brief the judge on what the difficulties will be. And if you are found credible by the judge, of course, the appeal can be allowed, which is a win for everyone.
Mr. B, I think even over the past decade, we've had this experience of such harsh and cold refusals that we don't really argue for that ever unless it is life or death.
Well, that's the problem, because if you have this Article 3 claim put forward to the Home Office, they're simply going to follow their Immigration Directorate instructions and the case law that exists on that. And the case law always has maintained a very high threshold to be met as far as evidential requirements are concerned. So I wouldn't suggest going under Article 3 unless it is absolutely life and death situation.
Got it. Thanks.
Thank you.